Keys to the Commonwealth, a podcast where we share the real stories of local community members who are using real estate to build personal wealth, along with tips and tricks from professionals across the industry. And now, your host, Landry Fields.
Welcome back, everyone, to another episode of our podcast. We are welcomed today by Jake Michul, who we're going to be kind of diving a little bit into the depths of commercial legal aspect of things, which obviously gets very, I'm sure, boring for most of us, but obviously it's very needed, very important topic when it comes to when we're in trouble or what we don't know and we need help as far as due diligences, when purchasing property, et cetera. So we're going to dive into maybe not too much detail as far as the nitty gritty, but as far as definitely an overview of what's good to know and so forth like that. So without further ado, Jake, thanks for coming on the show.
Absolutely. Thanks for having me.
Yeah.
As far as the nitty gritty, we'll try to stay a little higher level and not put everybody to sleep.
Right. So hop back in the door and then kind of tell us a little bit about yourself, how you got into the commercial law part of your world that you are in.
Sure. Well, as Landry said, my name is Jake Michul. I'm an attorney at Denton's Bingham Greenbaum. I'm a lifelong Lexingtonian. Mm-hmm. My uncle was a realtor. My dad was a commercial real estate broker in Lexington. Yeah. So I've been around that for a long time and always heard about it, been exposed to it, found it interesting. Yeah. Went to law school. UK undergrad in law school.
Was the background with your family what kind of led you into more of the legal realm of commercial law, or did that really not have a reflection on how you got into that part of it?
I don't know what led me into the legal aspect of it. I wanted to go to law school as long as I can remember, but I don't particularly remember exactly why. It was always just something in the back of my mind, even when I was a kid and had no clue what that even
So how'd you kind of fall into the commercial property or the property law and everything? I don't know, what's the technical term for it?
I just commercial real estate law, mainly from the transactional aspect of things. Obviously, there's litigation. Yeah. Everybody wants to avoid that. That's why you would call me earlier than later. Mm-hmm. Like I say, I'm a transactional attorney, so I'm working on negotiating, documenting, closing transactions. Started out doing a little bit of a broader practice in a smaller firm than I'm with now. Yeah.
Because you guys are you have a wide reach, I believe, right?
At this point, the firm I'm with, Denton's Bingham Greenbaum, is part of the largest law firm in the world. We've got offices in literally countries all over the globe, 12,000 lawyers, but we still here operate very regionally just because particularly with respect to real estate, the law is very location and jurisdiction specific, ranging from, not just the state level, but literally down to the particular municipality or city or county or part of city or county that you might be in.
And as I've talked about before, I mean, there's every city and county is different as far as their zoning laws or ways they probably do things. I'm sure
yeah, absolutely. There's not a lot. There's a lot of commonality in these days. Yeah. Commercial real estate transactional attorneys practice to a large extent, in different areas, using local counsel when needed for, state-specific things. So there's a lot of commonality, but there's also, particularly with respect to zoning and things like local custom, there's parts of a real estate transaction like the payment of closing costs that might not be in a contract or in a law, but there's just a certain way that it's done from location to location. And sometimes you can tell who's familiar with the area that they're in based on, the customs that they follow.
Right. So let's kind of talk about it from a couple different angles. But, I think the first part to jump into, the easiest part is, especially purchasing some kind of commercial building of some sort or something like that. Obviously, there's title involved. You kind of help out with that. But, what goes into as far as, the due diligence aspect, because obviously contracts or existing contracts can be a part of it. And I think you guys work with developing contracts or lease agreements as well. So talk about that a little bit.
So there's really
what I would need to know.
Sure. Three main pieces to what I do, and that's financing, leasing, and then, the development, purchase, sale, et cetera, aspect of things. So particularly with respect to the purchase of commercial real estate, you probably want to get a lawyer involved a little sooner than you might in a residential property, because there's generally more that goes into the due diligence, particularly if you're buying an existing commercial, development that's leased or in use, you want to make sure that it was zoned properly, that what's going on is actually compliant with the development plan. In many jurisdictions, Fayette County included, zoning enforcement is complaint driven. So don't assume that because something is there that it's allowed to be there.
Yeah. I think that speaks probably to the large aspect of how politics plays into probably a large part of development and what you all deal with and so forth, I assume, right?
Yeah, absolutely. And that comes more into play if you're doing a new development on a previously undeveloped piece of land, or a redevelopment, or putting a new use into a property. You need to look at what the zoning allows or doesn't allow. And
even then, politics is politics, and people just they just don't want it there. And even though it may fall into the realm of what it is allowed, there could still be pushback of trying to just find any way possible to stop something, right?
That's right. There's the issue of allowed. If it's clearly allowed, that's one thing. But there are situations where maybe it's questionable, or maybe it's conditional, and subject to some discretion of the Board of Adjustment, say. And you can have neighbors or different people in the community with different interests that might oppose or support you, depending on what you're doing and where you're doing it. So those are things that you'll want to look at early. And ideally, if your property is clearly zoned for what you want to do and you're not doing anything too controversial, it might be pretty straightforward. But there's still things that you'll want to look at earlier.
This is the big thing. Ultimately, you need people on your side within city councils and cities and stuff like that when you're going to be developing or doing some kind of big change to whatever you're purchasing, I guess.
Absolutely. You want someone who's familiar with the community you're in. That goes back to the local aspect of things. Each jurisdiction with zoning regulations is governed by its own local folks, and has practitioners who are there frequently or not. And it's always good to have people that are familiar with the area and familiar with the people, and can kind of guide you through the process. Because again, it's another one of those areas where it's there's a lot of process to it, and just knowing that and how to navigate that is valuable, and it's not always intuitive. You can go at it alone, but usually it's money well spent to consult someone who's familiar with the process.
So talk to me about the process then, as far as especially buying, the due diligence aspect. Obviously, that's one of the biggest keys to figuring out whether the property sale is going to go through, really where it's feasible from your net operating income, everything like that. So what's involved with that from your perspective?
And some of the things like income, purchase price, things like that, I defer to brokers and people who are a lot more financially attuned to those things than I might be. But from the legal standpoint, and getting past the zoning piece, which is very important, but a whole separate conversation in and of itself. We could talk about that all day. But if you have, for example, a property that's already leased, maybe a strip center or even a single tenant building, what does the tenant's lease say? Obviously, that's in most cases, where the value comes in that property. So you want to make sure that the lease says what you think it says. How much term is left? Are there any unusual, pass through or provisions or lack thereof? Meaning, in addition to base rent, commercial tenants typically pay some amount of triple nets or pass throughs or operating expenses or CAM, however it's styled, but none of those things have a specific meaning in and of themselves. Common area maintenance expenses are generally whatever the lease defines as common area maintenance expenses, and any given lease may include more or less than you expect. And I've had many situations where a client is looking at buying a property and the leases don't say what
they had a bad contract and things aren't defined clearly.
Exactly. Or sometimes they're just unusual one-off provisions buried at the end of the lease that rights of first refusal. That's another big one. Tenants will negotiate for those, and you don't want to get to closing or even close and realize that the tenant had a right of first refusal and we did not give them an opportunity to exercise that.
Interesting.
So
because from a habitational side, which I'm obviously more familiar with, those contracts tend to be pretty standard, 12-month, maybe you cover the lawn, maybe you don't, or as far as maintenance, but there's pretty standard aspects. Whereas, from a commercial standpoint, especially if you got, like you said, a little shopping strip, you've got a tenant in each one of those buildings. I mean, I'm sure you can run into where every contract's a little bit different. They're more usually, 2-year, 3-year, 5-year type contracts. That could be a range of different things, right?
Absolutely. And in an older property, they might have been entered into over a period of several years. You might have a 3-year lease, but it's been renewed 15 times. So that tenant is on a very different lease from back when they originally moved in.
Yeah.
Than, 3 landlords ago than the current form of lease. So that's just something.
Yeah. You got improvements, I'm sure, that come into play, right? As there's different parts of contracts as far as whether the client improves the property versus the owner.
Exactly. And that's a little more of a leasing specific thing, but in the context of due diligence, that's another good example. If you buy a property maybe with a tenant who's in the process of moving in, as the new owner of that property, you're essentially taking on the existing landlord's liabilities and obligations and rights. But let's say the landlord agreed to a $100,000 tenant improvement allowance that hasn't been paid. You want to make sure you're aware of that and that it's accounted for as a credit at closing, or accounted for in one way or another, so that either the seller is paying that, or if you're paying it, you're aware of it and it's factored into the overall economics, and you're not walking into a situation where you close and the next day the tenant calls and says, okay, here's my CO, I'm finished, where's my allowance?
Right.
So that's another example of things that are common, but there's also no specific way that it's done. There's a lot of, in general, it's the same, but the details and the way that it's written are done slightly different sometimes based on negotiations or preference or any number of different factors that are specific to the deal, whether it's people, situation, et cetera.
And then from the purchase side of things, I mean, I'm sure it gets more hectic, obviously from a title standpoint. Purchasing a house or a property, usually there's an owner or maybe a family member that partially owns it, probably a little bit easier. But I'm sure on a commercial standpoint, especially if there's been marriages have already been broken up, so I assume it probably gets a little bit more complicated as far as the due diligence on the titles perspective, where there's multiple entities a lot of times involved with different things, or is it maybe not that case?
It is, and not to say that you shouldn't do, title is not important to understand in a residential situation, because there are things like liens and restrictions and, deficient documents and things like that. So it's important there, but in the commercial context, it's also important because you're much more likely to have things like reciprocal access, parking, and or, et cetera, easements for adjoining properties. There may or may not be costs involved in that. It's not uncommon to find that, something wasn't written as clearly as it could have been, or that someone assumed that the easement extended to A, B, and C, whereas it only extended to A and B. Or maybe they thought it only extended to A, B, and it actually extends to A, B, and C. So
we'll dive into the easement. What do you, as far as defining what that really means, or in different examples or so forth like that?
So
those that don't know.
Let's say you've got a shopping center with 4 outlots, and the 4 outlots don't have direct access to a public street. They need to access the public street through the parking lot of the adjacent shopping center. Okay. And there are all different, ways that could have been set up in terms of ownership. If they're all under common ownership, there might not be an easement. So if you're buying that lot, you need one of those outlots.
One portion of it, then all of a sudden changes a lot of things.
You want to see if there's a recorded easement for access, and if not, you probably want to require one as a contingency to your closing, and negotiating and drafting that is something that we do. Okay. And in a lot of cases, that's done as part of the original development, so it's in place, and you're just looking to confirm, okay, this access is here, we have it, we're okay. Another reason that a survey is more important typically in a commercial context, because you'll see lots of easements in the title, and just reading them, you may or may not have a good idea of exactly where they are and how they affect your property. Easements show up in title exams all the time for a property that, because at some point there was some common ownership, but they don't actually affect the parcel in question. Or sometimes you find a sewer easement that runs under the building, or maybe runs under the empty lot that you plan to build on, and that's a big cost you don't want to be surprised by. So, a lot of things are much easier to avoid or fix in the beginning. It's kind of a generic quote, but an ounce of prevention is worth a pound of cure. It's going to be a lot easier and a lot cheaper to fix it or avoid it in the beginning than it is to resolve a dispute in the end. So there are things like that you want to look at. This is by far one of only one of many examples, but going back to the outlot in the shopping center context, another thing that happens in those deals is different tenants negotiate for exclusive use rights. They don't want certain competitors, within a close vicinity at a property controlled by the same landlord. So there might be restrictions on certain uses. You want to make sure that your intended use or maybe your existing use is not prohibited.
Okay.
A lot of development just prohibit things, like adult bookstores. Not that many of your listeners are doing something like that, but those types of provisions, it maybe less so today, but in the past, certain shopping centers prohibited gyms and fitness centers because they were less popular than they are now and not necessarily as desirable as they might be in a development. So there are lots of things that that bind the property, and they're generally speaking enforceable. And if they're not, you don't want to typically inherit a lawsuit. So some people do, but most don't.
What are some of those scenarios where, unfortunately, you guys have to get involved, not in the actual transactional aspect of property? Is there anything you have to get involved with or stepped in, or some of those reasons or examples ever?
So a big part of what I do is designed to avoid that and draft, specific remedies and very clear provisions. A lot of it can be
contracts even as well, right? Because I need to redo my contracts for how I do my leases and so forth, right?
Or the purchase agreement has very defined obligations and may or may not have very specific remedies. So by approaching it from the aspect of we're going to make this as clear as possible, you might look at your contract and say, why did we spend all this time doing this? Because, not that it always takes a lot of time, but why did we do this? Everything works out fine. A lot of times things work out fine because the documents are clear enough that everybody knows these are the lanes that I have to work within. And because it's clear enough, you don't have an issue.
Me being in insurance, I obviously understand a little bit about that, and it's just just how important it is to just have everything very defined. Because like I've seen in insurance, everything is every word down to exactly here's the definition of this word and specifically what it includes, excludes, et cetera, type of thing.
And so going back to that, what I do on the transactional side is anything and everything I can to avoid going to court. Disputes do arise sometimes. No matter what the contract says, disputes come up sometimes. Somebody comes to me with a document that may be new, it may be old, but for one reason or another, it's either not clear or one side is not performing. A lot of times that's in the context of, say, a lease dispute or maybe a dispute in a purchase agreement over whether somebody, exercised reasonable care to satisfy some particular contingency or exercise some right within a particular amount of time. Again, a lot of these things, when you look at that 40-page lease, it's 40 pages because it's addressing things that have come up before. So most of those provisions, maybe not as of late, but over the course of decades or more, leases went from being 1 or 2 pages to as long as they are now.
Because the reality is you can't think of every single scenario that's ever, and there could be unique ones just for that particular place that you've never come across before. So I could see that. That's
right. And certain lawyers are very focused on particular provisions and documents that other people aren't, maybe because they've had an experience where it became an issue. And a lot of times parties, clients have had an issue in, say, a casualty in a shopping center, and then we're faced with a bad insurance provision, and it did not work out the way that they felt was fair. And so they, even though they're unlikely to have that same loss again, they're very aware of how big of a problem it can be if it's not.
And that's what we honestly
drafted correct.
To that point, I mean, that's what we talk a lot with my clients that, have the shopping strips or the stuff where you've got multiple tenants as part of your lease. That's really looked at. I don't think most people know that most insurance is even looking at, like, who are the people that are in this spot? Like, is it, are we having some kind of a commercial cooking right next to something that's like, a woodworking shop or something like that? I mean, these, some of these things maybe don't add up, or maybe approach it from appear to be very higher liability risk if things aren't done appropriately. So that's a big issue. But also from I think a property owner standpoint, that kind of marries the contract and stuff like you, is like the idea of making sure that you're protected and requiring the correct liability limits or provisional things within the insurance that your tenant would have to help cover your butt, for lack of better words, as the property owner.
Yeah, exactly. And a lot of times, particularly with respect to a lease, I would direct my client to talk to their insurance agent. And, there's a lot of commonality, like all the things I'm talking about, but also a lot of variation in how insurance provisions are drafted, sometimes intentionally, sometimes inadvertently.
Yeah.
But just making sure that what you're agreeing to provide is, one, adequate, and two, available on commercially reasonable terms. And then three, that you don't have some sort of allocation of risk, without getting too much into the legal jargon, but waivers of subrogation where parties try to allocate risk to the insurance to minimize essentially agree not to sue each other to the extent that their loss is covered by insurance. I think to some extent that's a good thing, but you want to make sure it's drafted correctly and your insurance agent is aware of it, so you don't end up waiving claims and also somehow, interfere with your insurance coverage and end up with a gap. So,
because there can be a lot of scenarios. One of the ones that recently comes to mind, I was working on a large industrial warehouse scenario, and we've got to go in there. They had a sprinkler system, but one of the things people wouldn't think about is, well, does the sprinkler system, is it capable of covering and mitigating the amount of risk if there was a fire based upon what the tenant was doing inside of the warehouse? Thankfully this tenant was doing steel door frame scenarios, so that covered it. But if it was something where it was a lot more wood related or paper related or whatever, that's that whole very expensive commercial grade sprinkler system probably wouldn't have cut it and could close the shop on being able to find an appropriate insurance carrier for it, type of things. And so then you have to out the cost of trying to improve the capabilities of that. So a lot of facets of moving parts there.
Yeah. And if you have an unusual, user, tenant, landlord, whatever activity in your property, that's another situation where not a problem, but you just need to make sure that you've, looked into it and talked to the other appropriate professionals, or a property that used to be a service station, making sure that you do the environmental investigation, the phase 1 or phase 2 if necessary, so that you get some protections for having done your due diligence. Because otherwise, and this is a whole legal specialty in and of itself, but if you acquire a contaminated property, you are subject to some liability associated with that. And if you discover it after paying for the price of a non-contaminated property, and it limits what you can do.
Now and you can't undo the fact that that's there now.
And the situation is there. It was always there. You could have avoided it or paid less or factored cleanup or brownfield programs into what you're doing. Again, same with zoning. Some of these things are, usually don't come up to an extensive level on any given project, but you want to make sure that you've ruled them out. Even certain agricultural properties that have never been used for anything, it might seem clean, could have, depending on what was grown there and where it was located, have been heavily doused with some chemical that 30 years ago was, totally banned and determined to be very, very unsafe. So again, normally you're not going to encounter a problem, but again, it's that, the due diligence aspect, the consequences are significant. It's pretty easy to rule things out.
For sure. And then, part of the other part is, I assume you all kind of help in certain legal aspects for getting zones changed, if that's the case, or there's maybe a reason to present changing the zone, or based on what the buyer or purchaser is wanting to do, or the current owner is wanting to do with the property. I assume you all work with that in that sense as well.
Absolutely. Applying for zone changes, helping pursue development plans, in conjunction with the different engineers and other design people that are involved in those, helping to, kind of navigate some of the legal aspects and interpretation that's there. Short of a zone change, even if you're each zone generally has certain things that are permitted, certain things that are not permitted. Within that, there's bound to be other activities that aren't expressly addressed, and there's room for interpretation. And then there's certain things that are conditional. You can apply for a conditional use permit to do these things, meaning they're allowed, but only if you come make your case to the Board of Adjustment, and the Board of Adjustment, in its discretion, decides to allow you to do this, and they have a lot of discretion to do that. So there are public meetings, but there are also pre-application and various meetings depending on what exactly you're pursuing.
I assume from the legal side of things, you all probably have a lot of working relationships with different people as far as being able to advise, like, here's the, certain people you're going to need to either know or kind of get that person on your side, so to speak, to approve that. And so I'm sure the relational aspect for you all is a big portion of that as well when it comes to those particular things.
Absolutely. And that's one of the nice things about being in a bigger firm and having other colleagues who do different things and have their own experiences and relationships. I have a partner, Brandon Gross, who I work with, who does similar work to what I do and works pretty extensively in the zoning area too. So it's nice to have an office with a group of people who have different relationships and different experiences in the same, different yet the same. Not to say that we're not doing similar work, but have just a broader range of ability to help navigate whatever situation might come up.
Yeah, a lot to think about there.
Absolutely.
As we were going to wrap up, anything else to kind of that I don't know what I don't know to ask you in that sense, or does that about cover the basis of a lot of the without getting again down the nitty gritty?
Not necessarily. I think we covered a lot of things, even in the context of due diligence, some things that would also apply just in negotiating a lease. Some of those different provisions that I mentioned in the due diligence context really apply to negotiating and entering into a new lease. So that just kind of scratches the surface with some different concepts. But I would suggest contacting
how do we
commercial
contact
real
you all,
estate
though, as far as that goes? I mean, contact commercial realtors and stuff like that, but how do we contact you?
Sure. And again, my firm is called Denton's Bingham Greenbaum. You can find me at jake.michul, Michul, at dentons.com. That's my email address, or you can find me on our website just by Googling Jake Michul, Denton's Bingham Greenbaum. And I would just suggest that whether it's me or someone else, if you're embarking on something like this, especially if it's your first, kind of foray into a commercial project, calling someone and finding out what level of assistance you might need. And generally you'll find that level is, commensurate with the scope of your project, and so, but having someone who has been through the process and kind of help home in on the particular things that might be, particularly important. And, over the sliding scale of doing everything under the sun and nothing, figuring out what is reasonable, because sometimes everything under the sun, while it might be great, is not realistic. And so finding, someone who can help you, between a good broker and attorney and banker and, making sure that you've got the right people to talk to, I think is really the thing to do.
Nice. Usually always end with the last question is, what's your favorite thing about, Kentucky or Central Kentucky in that sense? If somebody was out of state or moving here, or what
my favorite thing about, I guess, Central Kentucky, being a Lexington native, I'm biased, but I think between the weather and the 4 distinct seasons and just having so many offerings between UK sports and the different concerts that come to, Rupp and Keeneland and, restaurants, I think we offer a lot more than people might realize.
Bourbon Trail. So many unique things that you don't find anywhere else.
Exactly, and things that you might not realize if you haven't been here, that you might associate with a bigger or more, bigger or more well-known or sort of area like, California or Florida or something like that. We've got a lot to offer here that,
I agree. And as we've seen over the last couple of years, it's not slowing down as far as I think that secret's kind of getting out of the bag a little bit nationally as far as that goes, it seems like, because I don't think we're slowing down as far as having develop and having a shortage of homes and places to develop or build right now type of thing.
Absolutely.
Well, Jake, appreciate you coming on the show.
Thanks for having me.
If we would, smash that like button, leave us a review, and we will see everybody back on next week's episode. Thanks, Jake.
Thanks.
To learn more about this podcast, visit our page at keystothecommonwealth.com. To connect with Landry regarding insuring your investment portfolio, email Landry at novainsuranceGroup.com or call 859-687-2004.